So I would like to introduce you today to the issue of Antarctic sovereignty and how it has implications on on exercising jurisdiction, but also on environmental protection. First of all, when we think of Antarctica, what usually pops into our minds are freezing temperatures. Indeed, the lowest temperature ever recorded on Earth was measured there at the Vostok Russian weather station. Also, penguins having fun in these freezing temperatures and conquering the South Pole by Amundsen in 1911. However, to see the Antarctic region from the political and legal perspective, we have to go a little bit back in time. So we should start with Bransfield, the British explorer, who embarked on a journey towards south because European countries exploited a large number of seals near their shores in the beginning of 1800s. They were looking for new spots of whales and seals where they reside. And we can say that Bransfield in 1820 first discovered the Antarctic band. And one thing I didn't mention in the beginning is that there is a difference between Antarctica and Antarctic. So the topic is about Antarctic, which is the whole southern polar region, while Antarctica only entails the Antarctic continent, in other words, the Antarctic landmass. So when Bransfield came to Antarctica in 1820s, there were lots of natural resources. However, the mineral ones were not yet discovered. But this nudged some states to secure their positions in case they find these minerals in the future, so they have an advantage to exploit them. And this way we come to territorial claims for sovereignty on Antarctica, which were laid from 1908 until the end of World War II. 7 countries laid claims for certain parts of Antarctica. The first one was the United Kingdom in 1908, and then they saw the opportunity to expand their influence in the region by transferring some of their rights to New Zealand and also Australia, which were dominions in the Commonwealth. Also France and Norway, as they were known as great sailing nations during that time, laid those claims, and the last ones to lay them at the end of the World War II were Argentina and Chile. The basis of these territorial claims are theory of discovery, which was mainly used by the European countries that are not close to Antarctica. And by this theory, one who first sees the continent or steps foot on the land or crosses some border claims that the area belongs to them. Another principle was uti possidetis principle, mainly used by Argentina and Chile, which cannot be applied here because this principle is mainly used and was mainly used after the end of the colonization area when the colonizers left. So this principle was established so that the nations along the borders were not in a violent conflict. And the theory of proximity was used by the nations closest to the Antarctic land: UK, Argentina, Chile, New Zealand, and Australia. Most importantly, none of these claims satisfy the requirements by the international law. The main method of acquiring territory which is under no sovereign rule is occupation. Of course, there are 3 elements of occupation. One is terra nullius, so there were no indigenous people there. Also, the land was under no sovereign power, so that element is satisfied. However, the 2 other elements were not satisfied. These were length of occupation, because the weather conditions and climate conditions in the Antarctic area are inhospitable for a longer stay in the area, so the state cannot exercise its power throughout the whole year. And also the effectiveness, because in some of these areas that the states claim, there are many research stations from other countries, but to have an effective occupation, one would have to exclude others from entering their territory. So to sum up this part of presentation, the international community does not recognize any of those claims, and de jure, the continent and the whole Antarctic region really belongs to no state. And even some claimant states do not approve each other's claims. Mainly UK, New Zealand, Australia, and Norway recognize each other's, and Argentina and Chile mutually recognize each other's. However, they do not recognize other claims. So this leaves us with the situation that around 85% of Antarctic land is covered by these territorial claims for sovereignty, and some of them are overlapping. As you can see in the graph, the United Kingdom, Argentina, and Chile's claims are overlapping, as well as France's and Australia's. And this led to tension in the area because of those overlappings. And eventually the UK brought actions against Argentina and Chile to the International Court of Justice, but the case was dismissed because of lack of jurisdiction, as Chile and Argentina were not obliged to submit themselves towards the jurisdiction of the court. And seeing the increased tension in the area, the United States stepped in, and they suggested some ideas to these claimant states, that they should regulate the area as a condominium, or maybe they should put the whole area under the trusteeship of the United Nations. However, the countries, and mainly Chile and Argentina, refused any idea that would kind of internationalize the area, which would undermine their territorial claims. And as it was the period of the Cold War, the former Soviet Union was left out of this conversation, but subsequently joined as the tensions came down in this area. What really came to the rescue to the countries was the International Geophysical Year, held in 1957 and 1958, which was a scientific project under the sponsorship of the United Nations, which wanted to examine some of the geophysical features of the Earth, and they decided to focus especially on space and Antarctica. And the claimant states then saw that when they shifted their focus from politics to science, they could cooperate much better. And that gave them a further boost for cooperation, that they could regulate the Antarctic area without so much tension. And the United States of America then organized a Washington Conference, which in the end led to the Antarctic Treaty of 1959. The Antarctic Treaty is the main treaty concerning the area. Nowhere in the treaty is explicitly stated that it applies to Antarctica, so it is important to know that it applies south of the 60 degrees south latitude, including ice shelves, but not the high seas, in order not to interfere with the international law. And the first 12 signatory states were those 7 claimant states: USA, the former Soviet Union, Japan, South Africa, and Belgium. These 12 states were scientifically most active in the region, and that's why those 12 states. And I should mention that today there are 54 parties to the treaty. They are divided in 2 groups, which is kind of undemocratic. 29 consultative parties can decide on the issues regarding Antarctica, while the other 25 do not have any right to vote. And that is because for a party to become a consultative one, they have to show an intense scientific intention in the region. The principles of governance stated in the treaty are that it should be used only for peaceful purposes, and as they saw in the International Geophysical Year, during the International Geophysical Year, they decided to encourage freedom of scientific investigation and exchange of all the information gathered while investigating the area. And the one principle that is not explicitly stated in the treaty, but one can infer from the all other articles, is that unanimous decision making is required in consultative meetings where consultative parties meet. So in order to regulate any question regarding Antarctica, there should be a unanimous decision. So one country out of these 20 can refuse to accept some regulation, and the regulation won't pass. The Antarctic Treaty is significant because it is the first international treaty to ban nuclear testing, and it is the first continent to be demilitarized and free of nuclear material, as disposal of radioactive waste is also prohibited in the area. And now we come to the most interesting part, which is how the treaty regulated those claims for sovereignty. The treaty actually didn't regulate the sovereignty issue. As one author put it, it is actually a political anesthetic, and it reinforced the status quo in the area, as no acts or activities that would take place in the area would reinforce, support, or deny a claim, nor will a new claim be asserted for an enlargement of an existing claims, for example, claiming a larger part of a continental shelf to be inserted while the treaty is in force. And what we have as a conclusion of this article, that 85% of the territory is under frozen territorial claims. They are not internationally recognized, and even claimant states do not recognize each other's claims. And the remaining 15% of the territory is, this depends on the interpretation, either res nullius, meaning belongs to nobody, or res communis omnium, meaning belongs to everybody. And now we come to the jurisdiction in Antarctic region, which is also a consequence of not solving the sovereignty issue. As they cannot come to an agreement regarding the sovereignty issue, they decided to, according to the Article 8, base their jurisdiction on nationality of scientific personnel and observers from the contracting parties. And in case there is any dispute in jurisdiction, an immediate consultation shall be held. But as you can see, there is a jurisdictional void. They didn't regulate how jurisdiction should be exercised on visitors, tourists, and also third-party nationals. So what we have in theory is that territorial jurisdiction is exercised over claimed sectors. So the United States, for example, France would exercise its jurisdiction over its territory, but they would only exercise it on its own nationals, not to cause any tension in the area. Also, it is nationality based according to the Article 8, and station based, and we can put flag state jurisdiction analogy here, as the jurisdiction is also on the high seas. States that own the vessel exercise jurisdiction on that vessel. So if United States have a research station in the Antarctica, they exercise jurisdiction on that research station. And as you can imagine, this is a perfect mixture to cause chaos regarding jurisdiction and possible conflicts of jurisdiction. Let's take, for example, that a tourist of one contracting party, let's say United States, commits a crime on a territory claimed by other contracting party, let's say France's territory. If America wants to exercise its jurisdiction regarding on a nationality-based principle, then France would not exercise its jurisdiction, which is an important part of sovereignty, and they would undermine its own territorial claim for sovereignty. On the other hand, if France exercises its territorial claim, territorial jurisdiction, then America would refuse to accept this jurisdiction because they do not recognize France's claim for sovereignty. One real-life case was that of Rodney Marks in 2000. He was an Australian scientist working in an American station, Amundsen Scott South Pole Station, which was situated at New Zealand's claimed territory. So again, perfect mixture. America led the initial investigation, and after that, the body was transferred because he died of a suspicious cause. And after that, the body was transferred to New Zealand for further investigation. But the Americans did not provide the New Zealand's authorities of any information regarding the initial investigation because they were scared that by providing any information, they would support their territorial claim on this part of the territory. What is, I think, of most interest to you, all criminal law people, is which criminal code is in force in the Antarctic area. What about the 15% that is under no rule, no sovereign rule? Which criminal code should be applied there? But also, let's say a Croatian tourist or Lithuanian tourist, which are not parties to the Antarctic Treaty, comes to a visit on Antarctica on an internationally unrecognized territory. How do they know what constitutes a criminal act there? Who has jurisdiction over them? There are so many open questions there, which there is no answer yet. And regarding tourism, as the topic of the seminar is also the environmental protection, I decided to use tourism because it nicely illustrates all the underlying problems of the Antarctic Treaty system and how it affects the environment. In 1991, the consultative parties adopted a protocol on environmental protection, and its significance is that it is the first international treaty to regulate environmental protection outside national jurisdiction. But as we know from international law, states that are not parties to the treaties are not bound by it, only if the provisions become customary law. So tourists from non-member states are not bound by the protocol and its regulations regarding protection of the environment. And according to the statistics from Antarctic tour operators, around 40% of vessels from non-member states enter the Antarctic region. So they are not bound by the Antarctic Treaty nor the protocol. Plus, what is a further problem is there is no sovereign state to protect territorial and internal waters. If France was, for example, the sovereign state on one part of Antarctica, they would exercise its sovereignty on territorial and internal waters, and they could see whether the states obey the rules of the protocol. The main reason tourism is not regulated in the region, except protocol on environmental protection, is that Australia, Argentina, and Chile think that it supports their territorial claims for sovereignty as they organize trips to Antarctica. And also it is difficult now, as you can remember, as was mentioned earlier, how could the 29 consultative parties agree on regulating such a conflicting issue of access of tourists to Antarctica when they have to unanimously decide? To see that this problem is not minor, we should use the Antarctic tour operator statistics that during the 2019-2020 season, around 75,000 tourists visited Antarctica, and most of them were landed visits, which are in the summer season, when is the breeding season of most animals. So they add additional stress to animals and lower their population, lower the population of the wildlife there. To conclude, the Article 4 was great innovation in the 1950s because it reduced tension in the area, but now it is a hindrance to improvement, and the root of all problems are unresolved sovereignty issues and states clinging to possible exploitation of resources and profit in an ecosystem that is already fragile, not to mention the occurring climate change and global warming. One other problem is this unanimous decision-making, which made sense when there were only 12 signatory states and they could decide unanimously, but now there are 54 and 29 of them have to unanimously decide on the regulation of tourism, of possible enactment of criminal code. So my solution would be to switch to a two-thirds majority and to abolish the undemocratic distinction between parties based how they have intense scientific intention in the region. Why? Because as we could see earlier, the jure, the Antarctic region belongs to nobody. And a utopian, but I would say a common sense solution to the Antarctic problem would be to have a radical shift in thinking, and that the states renunciate their territorial claims, because they have to understand that de jure and de facto they cannot exercise occupation. It belongs to no states but to humankind as a whole, as the zone of the high seas, the bottom of the high seas. And most importantly, they should stop looking at the Antarctic environment. By that I mean plants, wildlife, resources, ecosystem, in terms of monetary value and resources, and protect it per se, because, as I said, it belongs to nobody, and we should really cherish it as it is some kind of a global refrigerator in this global warming era. So yeah, that would be the conclusion, and I'm looking forward to hearing what you think, how the criminal points should be solved. What should the criminal code be enacted, and how should the jurisdiction regarding crime be related? But there is not a lot of crime there, only small fights between scientists when they drink a bit. But it's going to become more complex as more and more tourists arrive. So thank you for your attention.
Thank you, Nikola. Sunčana, do you want to take over right now or in a few minutes? Either way. I already see that there are a lot of questions in the chat area, so you raised a lot of questions. Sunčana, please.
Maya, you're so good, so you can start, and then I can have one question at the end. But I'm very proud, before I let you continue to do the perfect job that you're doing. I'm very proud of Nikola. I'm sure you are as well, Maya. And maybe just for our student assistant, that some of them are with us. And it's very great to see how our students, which are very interested in certain topic, develop the knowledge on that topic and are able to really present it very well. So great, Nikola. Now, Maya, please, and I have one question later on.
Thank you.
Maya, I think you turned off your mic.
I did. Anyway, here I am back again. So I said I have 9 more minutes to moderate this session, and then unfortunately I have to leave. And as I said already, immediately after your lecture, you raised a lot of interesting points, and many of them are not just important in terms of protection of Antarctic, but will continue to be important with respect to other future resources, as Zoran Vinkovic, and I'm not going to steal his question from him, but as he said, could this be a rehearsal for the future colonization of Mars? Zoran, I know you're here. Please come and pose your question yourself.
Hello.
Hello.
Hello. Hi. I have to say it was really, really refreshingly interesting presentation. So my question is, I will just read what I wrote. Sooner or later, due to global warming, the mineral resources of Antarctica will be exploited. In your opinion, can the problem of jurisdiction be solved by a special body or committee composed of several states or international organizations? And in this regard, how much influence can have private companies in this, which will certainly show interest in doing their job on the continent? And also my second question is, could this be a rehearsal for the future colonization of Mars? Thank you.
Yeah. Okay, I suppose I could divide this question into three parts. One would be international organizations and special body committee. By that, the United Nations, the third parties wanted to influence the decision making in the regarding Antarctica, because they were not developed to gain a consolidative status, and they wanted the conversation to shift to the United Nations. However, there was a problem there, because when the consolidative parties came to the United Nations, they refused to vote on anything that was not unanimous. And in the end, there was a stop in conversation in the United Nations for, I would say, 12 to 13 years, from 1982 until 1994. But also the third countries were interested in exploiting mineral resources, because they thought they would be left out of the conversation. And now to come to the second part and to kind of join these two questions together, the Antarctic consolidative parties wanted to regulate mineral resources in Antarctica, and they even adopted the Convention on the Regulation of Antarctic Mineral Resource Activities in 1988. However, this convention was not ratified because Australia and France opposed it. And Australia imposed it. They say they opposed it because of environmental protection, but the reason behind it was they did not think that they gained a lot of respect, and they would not be compensated for the resources exploited on their part of the territory. So the environmental protection was kind of put to the front, but those were the underlying issues. And I think for the rehearsal of the colonization of Mars and private companies having their influence, I think it will be the same as it is with tourism. They will not come to a unanimous decision. They will see it as further re-establish their territorial claims. They will say, "Oh, France's company is doing business there, so that confirms our territorial claim," and so on. And regarding the mineral resources, the year, if I'm not mistaken, 50 years from the entering into force of the Protocol on Environmental Protection, this protocol can be amended, and in Article 7 it states that all activities regarding mineral exploitation and research will be prohibited unless for the scientific reasons. But in 50 years, so in 2048, if I'm not mistaken, this protocol can be amended. So we have to wait until 28 more years. But what is good is that there are some safety mechanisms that the mineral resource convention should already be in place. And as we could see, the convention is not ratified by any of the states, so 0. And they would have to gain 2/3 majority, which would be, I think, 28 countries would have to agree. So it is kind of difficult to expect that they would agree on exploiting mineral resources, but who knows, in 28, the direction we are heading to right now with world climate change, global warming, I doubt that we could say for sure what will happen.
Thank you. I don't know if Maya is there.
I'm still there, but I'm now leaving. Lara Savage posed another question. Bye, everyone.
Bye.
Have a nice rest of the day, and I'll hope to see you later. Bye.
Thank you. Okay, Lara, we have a couple of more minutes and then we have to continue here, but you raised a lot of questions. Is there freedom, what Lara was asking, is the freedom of scientific investigation a cooperation that is guaranteed by the Antarctic Treaty limited because of the possibility of complete freedom to lead to destruction of ecosystem?
Yes, this is a good question, and the protocol on the environmental protection is really a safeguard here, because it establishes the environmental impact assessment, and it refers to all activities, not only tourism, exploitation, but also to scientific investigation. So if they saw that a minor or major impact is held, then the impact assessment should be conducted. But what I didn't mention in the presentation, because it's not really specified to the crime, is that nobody observes the states how they enforce the protocol and all the annexes to the protocol on environmental protection.
Yeah.
Because of the tension in the area, they only have national reports, which are every few years. Nobody looks at them. There is a committee on environmental protection established by the protocol. It has only advisory function. Nobody can sanction them. Imagine what would happen if somebody sanctions those countries when there is so much tension around territorial claims. It would be complete chaos.
Yeah, thank you. Thank you. Can you then briefly also address other topic? Do you know which foreign, from Michaela, do you know which foreign country's legislation has the greatest impact on the jurisdiction? And then even what would be the best way to close the legal gaps, right? Can you maybe address, first of all, who has the most power right now?
Who has the most power in the region?
In the legislation, you know.
Yeah.
I like the question also, it's very...
Let me think for a little bit, because it is pretty complex. I think because of the unanimous decision making, all 29 countries, for example, not to offend anybody if he's from Slovakia, but Slovakia as a party to the treaty, as a consolidated party, has the same influence as the United States, which is not a claimant state, and also France or Australia or New Zealand, which are claimant states. So regarding regulation, each of the 29 has the same power.
And how then to follow Mare and Ivana, how to actually fill the legal gaps? What about liability for consequences?
The liability for consequences regarding environmental protection was really interesting, because in Annex 6 to the Protocol on Environmental Protection regulates liability. And firstly, they wanted to regulate the liability of private companies. And they somehow came to some kind of agreement, but they didn't adopt it. And that fell apart. So now they try to regulate liability of states in the area for any environmental emergency situation that would cause damage, oil, a spilling of oil, and so on. But they continuously postpone the ratification of the treaty. In 2005, they said some of the states ratified it. I think 16 out of 28 ratified it. And then they said in 5 years' time, we will have another consultation so that you really ratify it. Then in 2010, they said, oh, let's do it in five years' time, because then it will be 10 years from the enactment of this annex. Then in 2015, they said, let's do it in 2020, but now this show of coronavirus pandemic, they didn't meet, and they didn't put any liability on the states for the environmental protection. But it is really hard to regulate the environmental protection because we don't feel close to Antarctica. It is so far south, so far from us. We don't see a direct impact as it is with climate change and global warming.
Okay. Okay, so there are lots of, as Ivana also detected, lots of questions that need legal answer. And I Googled a bit while listening to you, answering the question. There are many possible resources: silver, copper, gold, nickel, platinum, iron, cobalt, zinc, ice. It said that Antarctica's ice accounts for 90% of the world's fresh water. So I can see already lots of reasons for future disputes.
Yes, and it is said that underneath the Antarctic land and at the bottom of the sea, the surrounding Southern Ocean, there are reserves, oil reserves, third largest in the world, behind Saudi Arabia and Venezuela. Around, I don't know how many billion barrels of oil are there. So, but that is just an estimation, but it is probably true.
Thank you. Thank